Dear learners, I welcome you all to this class today. And in our last class, we discussed about the adoption of the ICCPR, and then we discussed how it was adopted, why it took such a long time. For example, from 1948 to 1966, almost 18 years to complete, the drafting and then bringing it for adoption. All the factors that were responsible we have already discussed. We also discussed the preamble, how the preamble is citing the UN Charter and then the Universal Declaration of Human Rights, and then what is the significance of preamble uh, in this covenant we have already discussed. Now, today we are going to discuss the significant provisions. As mentioned earlier, that the ICCPR has a preamble and 53 articles. Of course, all the articles cannot be discussed in one class. So that is why we are going to discuss main provisions, and the learners are motivated, and I will motivate you all to see the provisions and all the articles of the ICCPR, so that you can have a better idea of all the provisions, and especially the language is also important when that is being used in this kind of, what is the difference between shall, may, must, all, when it is being mentioned in this kind of document. So that is why it is important. You'll find Article 1 is dealing with right to self-determination. So this is important, right to self-determination. Why? Because you see, colonialism, that was their indigenous people, they were facing there was a threat to their culture, cultural heritage, language, their, everything, their style of living. So whether the people reeling under colonialism and imperialism, or the indigenous communities, non-dominant communities, they all had this kind of threat. So that is why what is being mentioned, right to self-determination, important, that is being recognized. Then you will find in part 2, because we have divided the significant provisions into 6 parts. So the first part is dealing with the right to self-determination. Then part 2, it deals with right to non-discrimination and the right to an effective remedy. You see, when we are talking about right to non-discrimination, it means the integral part of all human rights treaties of the United Nations. You will find that is the principle of non-discrimination. So at that time, in 1966, what was emphasized is that there shall not be any discrimination on the ground of race, religion, language, sex. So, gender equality, and then the equality on all other grounds. So racism was also there. Apartheid was there in the different parts of the world. So, non-discrimination is being emphasized. So Article 2 to 5, in part 2, they are dealing with the principle of non-discrimination and effective remedy if the discrimination is there. Then part 3rd, again you see from Article 6 to 27. So Article 3, for example, it discusses equal right of men and women to the enjoyment of civil and political rights in the ICCPR. Article 6. Every human being has the inherent right to life. This right shall be protected by law. No one shall be arbitrarily deprived of his life. So you see that again the procedure established by law is to be followed. No one shall be arbitrarily deprived of his life. That was emphasized. Article 7. No one shall be subjected to torture or to cruel, inhuman, or degrading treatment or punishment. In particular, no one shall be subjected without his free consent to medical or scientific experimentation. So, you see, why Article 7 is so important. No one shall be subjected to torture or to cruel, inhuman, or degrading treatment or punishment. At that time, you'll find that many countries were having the punishment method that were cruel, inhuman, and sometimes degrading. For example, it is often reported from the different parts of the world that the repressive apparatus of the state, that includes police, army, paramilitary forces, or the security agencies, intelligence agencies, they go for what is called torture or the cruel, inhuman, or degrading treatment or punishment. In the language of the police is called third degree torture. In many cases, it is reported by the human rights organization across the globe that the helpless people in the custody of the security agencies or the police, they are sometimes made to drink their own urine. That is what is called inhuman and degrading treatment. Sometimes sexual exploitation, as it was already highlighted what happened with the prisoners in Abu Ghraib prison in Iraq. So, this kind of things, when they were being reported, so that is why, under this kind of circumstances, that it still prevails today even. So that is why, this is a very important article. And it is not only this, inhuman or degrading treatment or punishment that is being mentioned here, but you will find subsequently, you'll find United Nations also adopted a convention against torture, a specific convention against torture. So torture, inhuman or degrading treatment or punishment is a universal problem, and that is why it has been universally accepted as a problem, and this is the reason that the United Nations had to adopt a separate treaty or conventions against inhuman treatment, punishment and torture. It is also specifically mentioned in no particular in particular, no one shall be subjected without his free consent to medical or scientific experimentation. Again, Article 8. No one shall be held in slavery. Slavery and the slave trade in all their forms shall be prohibited. You see, again, this is important. That slavery is being abolished. Slavery is being criminalized. And what is being proclaimed, that slavery and the slave trade in all their forms shall be prohibited. The slavery can have many forms and manifestations. For example, begar or the bonded labor in our own country can be termed as slavery. So, slavery in any form or manifestation shall be prohibited. When the expression shall is there, it means it must be prohibited. Article 9. Everyone has the right to liberty and security of person. No one shall be subjected to arbitrary arrest and detention. No one shall be deprived of his liberty except on such grounds and in accordance with such procedure as are established by law. So, arbitrary arrest or the arbitrary detention, that is being declared as illegal in the light of this law. And what is there? That there must be a procedure established by law upon which, based on which you can, the authorities can arrest a person or, detain a person. So it is a right against arbitrary arrest and detention. Article 10. All persons deprived of their liberty shall be treated with humanity and with respect for the inherent dignity of the human person. So, first of all, it is prohibiting that no person should be arrested or detained without the procedure established by law. It means the procedure established by law must be followed while arresting or detaining a person. That is an international obligation of every country who is a party to this covenant. But if the person has been arrested or detained, then what should be done? All persons deprived of their liberty shall be treated with humanity and with respect for the inherent dignity of the human person. So it means if the person has been detained, he should not be brutally tortured and he should face what is called inhuman, degrading treatment and punishment, torture, etc. Article 12. Everyone lawfully within the territory of a state shall, within that territory, have the right to liberty of movement and freedom to choose his residence. So again, this is there that freedom of movement and the freedom to choose his residence, that should be given to everyone according to this article. Article 14. All persons shall be equal before the courts and tribunals. The equality before law, what is called legal equality, uh, or the legal justice. So equality before law and equal protection of law is being emphasized. Article 16. Everyone shall have the right to recognition everywhere as a person before the law. So that is that recognition as a person before the law, that is to be recognized. So it means then only the person can get the protection of law. Article 17. Right to privacy and family life. This has been, so family is being recognized as an institution, and as the basic unit of society. So the right to privacy and a family life, that have been ensured through this article. Article 18. Everyone shall have the right to freedom of thought, conscience, and religion. You see, the freedom of thought, conscience, and religion. This right shall include freedom to have or to adopt a religion or belief of his choice. So everybody has got the right to have or to adopt a religion or belief of his choice. So it also includes right to convert or right to leave a religion. That is implicit in it. So that is why it is called, the freedom of thought, conscience, and religion of his choice. And freedom, so it mentioned that this right shall include freedom to have or to adopt a religion or belief of his choice. And freedom either individually or in community with others and in public or private to manifest his religion or belief in worship, observance, practice, and teaching. For example, mass prayer, congregational prayer, congregational puja, whatever, all these things are included in it. Article 19. Everyone shall have the right to freedom of expression. This right shall include freedom to seek, receive, and impart information and ideas of all kinds, regardless of frontiers, either orally or in writing or in print, in the form of art or through any other media of his choice. So, it was drafted in 1966. Of course, at that time, you see that the IT revolution was not there, or the massification of IT revolution was not there. Now, after the massification of the IT, this rights become very, very important. It is not recognizing frontiers as, the frontiers or the political boundaries as a restriction to share or receive information. So by this way, if you are, living in your own country, or you are, pursuing this course by sitting in a remote area or a remote village of any of the states of the country, from there you have every right to access all the information that is available, and regardless of frontiers, either orally or in writing or in print. So that way the internet has made it easier. Now you can have access to information, or the knowledge sharing that has become easier. So by sitting here from Aligarh Muslim University, I am reaching you, and I am discussing this. So that is why you see that this has been recognized. So it was drafted in 1966, but you'll find its relevance in our time has become more significant. Article 21. The right of peaceful assembly shall be recognized. So again, peaceful assembly, all the communities, all the people, they have got the right to peaceably assemble. So that, you cannot say that you cannot assemble, that state does most of the time in the name of national security or industrial peace or law and order problem. but that is the domestic jurisdiction of a state. Uh, you know, but however, people have a right. The right of peaceful assembly shall be recognized. Article 22, right to freedom of association. The people can form their own association. They can participate in the association. They can, become the member of the associations and all. Article 23, the right of men and women of marriageable age to marry and to found a family shall be recognized. That is again, marriageable age will be determined by the states. Of course, this ICCPR is not determining the marriageable age, but the marriageable age, for example, in any country maybe, in our country it is different. It may be different in other countries. That cultural diversity will be recognized, but the right of men and women of marriageable age to marry and to found a family shall be recognized. So again, you will find what is being emphasized, that marriage as an institution, family as an institution, and the right, men and women, they have a right to marry. Of course, here transgender or the lesbian and the gay, they are not being mentioned now. The contemporary discourse on human rights, it is trying to become gender sensitive, and when we are trying to engender human rights discourse, this article 23 needs to be understood, that when we are trying to engender human rights discourse, it is being said that the marriage should not be perceived only between men and women. The other sexes are to be recognized, and that is why the other kind of marriages should be also recognized. So that is why, in this sense, the men and women are, not only these two genders are not there. So the contemporary discourse on LGBTQ rights or the sexual minorities rights, all that is trying to expand the horizon of this article by emphasizing that it is not only men and women, but the lesbian marriages, gay marriages, they all should be recognized and legitimized. Article 25, a right to vote and to be elected at genuine periodic elections, which shall be by universal and equal suffrage. Again, what is being recognized? That is one of the best, one of the most important pillars of liberal democracy, and that is right to vote. And it is not only right to vote, but it is right to vote should be based on universal adult suffrage without any discrimination. It should be given to all the people who have attained a particular age, which is determined by the states, of course. Article 26. All persons are equal before the law and are entitled without any discrimination to be equal protection of the law. In this respect, the law shall prohibit any discrimination and grant to all persons equal and effective protection against discrimination on any ground such as race, color, sex, language, religion, political or other opinion, national or social origin, property, birth or other status. Again, equal protection of law and equality before the law. Article 27. In those states, this is significant. In those states in which ethnic, religious or linguistic minorities exist, persons belonging to such minorities shall not be denied the right in community with other members of their group to enjoy their own culture, to profess and practice their own religion, or to use their own language. You see, in Article 27, the UDHR, the Universal Declaration of Human Rights, was criticized for not having a provision for the protection of the rights of minorities. But in Article 27, what is happening here? You see, this is a significant aspect or the feature of this ICCPR, that Article 27 is mentioning the rights of minorities. And you see the language. In those states in which ethnic, number one, religious or linguistic, ethnic, religious or linguistic minorities exist, persons belonging to such minorities shall not be denied. इसका मतलब, what does it mean? It means they must not be denied the right in community with other members of their group to enjoy their own culture, to profess and practice their own religion, or to use their own language. So that is where the issue of mother tongue. That is important. What is happening that uh, the UNESCO is already alarming us all over the world that many languages are dying. The globalization is also leading to the death of many languages. Many cultural traits are also disappearing, and that's why it is also said that the death of a language is also death of an idea. So that is why therefore the people have got the right to preserve and promote their language, whether they may be in a small number. So that is why the rights of minorities are being linguistic minorities, for example, the minorities, religious minorities, for example, or the ethnic minorities. So they have every right to profess and practice their own religion or to use their own language. At the same time, they have every right to preserve and promote their own culture. Then part fourth of this ICCPR deal with uh, right to the establishment and working of the Human Rights Committee. That will be dealing later on when we are going to discuss the implementation mechanism. Then part fifth, that is Article 46 and 47, you will find this part of the ICCPR clarifies limitations on the covenant's scope, including respecting the UN and the right to natural resources. So this is again trying to explain the provision. So that is the explanatory part of the ICCPR. Then you have part 6 of the ICCPR from Article 48 to 53. So part 6 of the ICCPR deals with ratification, entry into force, and amendment of the covenant. All these things are there. So, with this, the provisions we have already discussed. After that, you see, we have been emphasizing the point that the UDHR is merely a declaration, so that is why it does not have implementation mechanism. We also discussed that in the UN Charter, you will find it deliberately the term promotion or observance was used for human rights, not the protection. Why? Because you will find UN Charter did not create any international mechanism of protection of human rights. So that is why you see that we discussed that declaration and the covenants are different, because in declaration you don't have implementation mechanism, whereas in the covenant you have effective implementation mechanism. So now this is the main difference between the Universal Declaration of Human Rights and the ICCPR. So here we are going to discuss the implementation mechanism under ICCPR. So the ICCPR provides for three methods of implementation, which are as follows. There are three ways of implementing human rights under International Covenant on Civil and Political Rights. Number one, the reporting procedure. This is a compulsory procedure. It means all the party, when I'm saying that this is a compulsory procedure, it means all the parties to this treaty or International Covenant on Civil and Political Rights, they have to compulsorily go for reporting procedure. It means, after becoming the party to this ICCPR, within 1 year they will submit their first report. And after that, the periodic report is to be submitted after every 5 years. This is compulsory for all the countries or all the member states who are the party to this, covenant. What happens that most of the countries, they do not follow this, and that is why the reports that the countries are supposed to submit after every 5 years, that is the periodic report, they do not submit these reports on time, and most of the countries they delay it. So the delay itself is creating a lot of alarm that why the country is delaying. It is a deliberate delay, or there are other factors responsible. So that way the country is criticized for delaying. But this has happened. But this is compulsory for all the countries. So first of all, what do you have to keep in mind, that within 1 year they have to submit one report after becoming the party to it, and then after every 5 years the this they have to submit a detailed report and to the Human Rights Committee, where there will be a discussion on the report that is submitted by the countries. But keep in mind that this report, the reports that the countries are submitting, they are not the stakeholders all alone, because there are other stakeholders. For example, you'll find international human rights organizations like Human Rights Watch, like Amnesty International. Then you'll find social and human rights activists from that country or from other countries. They are also there. So when the report is being submitted and when it is being discussed, then you'll find it will be corroborated by other agencies and other organizations. So that is why that it is not only that it will be an eyewash. The countries are condemned, they are criticized, and you'll find a lot of criticism that they face if they have violated human rights under the rights that are mentioned in the ICCPR. Then the second procedure is the interstate complaint system. This is an optional procedure. So, the first one, that is the reporting procedure, is compulsory, but the interstate complaint system is an optional procedure. So, the countries may go for exception, they may accept it or not. So, under interstate complaint system, what happens that the countries may agree that if the violation of human rights is there in one country, then the another country can report the violation of human rights, that are the rights that are mentioned in the ICCPR. But for this, both the countries should agree, for this. So that is called interstate complaint system. For example, you see, of course, this is not there between India and Pakistan. They have not agreed upon it. But I'm just, for the sake of example, I'm saying that if there is violation of human rights in Pakistan, then India can report. If there is violation of human rights in India, the Pakistan can report. This is there, but they have not agreed upon it. Means there is nothing like interstate complaint system between India and Pakistan. That I should make it clear. But this is the procedure. Then the third one is individual petition system. This is the third procedure or method of implementation under this ICCPR. And it is an optional procedure applicable to those states who ratify the optional protocol in addition to the covenant. So the country, this is an optional protocol. Without ratifying this optional protocol, the country can be the party to the ICCPR. But if they have agreed upon it, then individual petition system is there. So if there is a person or any individual who feels that his human rights that are mentioned in the ICCPR or the rights mentioned in the ICCPR have been violated by their government, by their state, or by others in his own country, then after exhausting all local remedies, means in the domestic jurisdiction of a country, after exhausting all local remedies, they can report the matter to the Human Rights Committee. So that is the individual petition system, but this is again optional. The monitoring body of the ICCPR, the monitoring body of the ICCPR is the Human Rights Committee, that is HRC. This monitoring body of the ICCPR, the Human Rights Committee, consists of 18 members who are expert, of course, expert member committee it is, 18 members of high moral character. They are the people of high moral character and integrity and recognized competence in the field of human rights. These are the people who have recognized, their credentials, established credentials in the field of promotion and protection of human rights. So these people are the members of the, this Human Rights Committee. It is 18-member body. They are elected for a term of 4 years by state parties to the ICCPR. So, these members, they have a term of 4 years. First optional protocol to the ICCPR. The first optional protocol of the ICCPR was adopted by the United Nations General Assembly on 16 December 1966 and came into force on 23rd March 1976. So it was adopted, with the charter, with the covenant itself. It establishes two important procedures: the individual communication procedure and the inquiry procedure, allowing individuals and states to bring complaints about alleged violations of the ICCPR to the attention of the Human Rights Committee. There are 35 signatories and 116 parties to it. The second optional protocol to the ICCPR, second optional protocol to the ICCPR was adopted by the United Nations General Assembly on 15 December 1989 and entered into force on 11 July 1991. It commits states parties to the abolition of the death penalty. So you see that it was originally not there, but this optional protocol was adopted in 1989 and came into force in 1991. And under this, the state parties, if they sign this optional protocol to the ICCPR, it means they agree to abolish death penalty. So, for the abolition of death penalty, you will find human rights organizations like Amnesty International, like, Human Rights Watch, and several other organizations and activists, they have been working on it. And that's why the result was that adoption of the second optional protocol to the ICCPR, under which the countries or the state parties to the ICCPR or to the optional protocol commit that death penalty will not be a punishment in their respective countries. So now we are going to conclude our lecture on the International Covenant on Civil and Political Rights. So first of all, you have to note that promotion of human rights has been one of the basic agendas of the UN and its various agencies. So from UN Charter to the other instruments of other documents and the instruments and the various articles of the UN Charter, if you see, or the organs of the United Nations or the agencies of the United Nations, they have been entrusted with the responsibility of promotion of human rights. However, this large-scale promotion has not directly ensured the protection of human rights globally. So you see that this is there, but at the same time, this is also a fact that human rights violations are reported from all over the world. So still, we cannot say that we should celebrate that human rights situation is very good. Most of the time, we will find that the state themselves are responsible for violating human rights. Nonetheless, the consistent promotional efforts by the UN and its agencies have led to an international awareness about human rights. This in turn has led to the establishment of regional instruments of human rights. So it is not only that you have this instrument of human rights under the aegis of the United Nations, but there are many regional instruments of human rights as well. For example, American, African, and the European Convention on Human Rights are there. So these regional mechanisms have been also there, and they are also trying to protect and promote human rights. And some of these regional instruments of human rights, they have more effective implementation mechanism in comparison to ICCPR. The International Covenant on Civil and Political Rights and the two optional protocols is a hallmark effort by the UN for protection of human rights. We discussed, that from promotion to protection. So that is why, this ICCPR can be understood in the context of the United Nations effort in the beginning to promote human rights globally and then moving toward what is called the international protection of human rights. With this, we conclude our lecture today on ICCPR. In the next lecture, we will be dealing with International Covenant on Economic, Social and Cultural Rights. Thank you very much.